So we've got two chapters I want to go over tonight. And this is our second to the last webinar. We've got this week and next week, and then we're done, y'all. So exciting. One less class to have to deal with, right? And
Yes.
but I'm excited about that too. I know students never think their professors are as excited about school winding down or anything being less intense than they are, but we really are. I like it when a class winds up. I do really love this class though. This is a fun class to me. The subject matter is so interesting. And so I enjoy this class, but it's kind of intense, and it's good when it winds up. So we'll I'm gonna share my screen then, and let's see. We'll look at our PowerPoint tonight that covers two chapters. The chapter on IEPs and then the one on due process. So we'll go through that, and y'all will be the lucky ones that get a couple of quiz questions for free. Okay, so
I'll take it.
okay, good. I'm not going to belabor these first few slides. John Roberts did say this, which is a good quote about the IEP. He said this just a few years ago when the Andrew case was settled by the Supreme Court. An IEP must aim to enable the child to make progress. The essential function of an IEP is to set out a plan for pursuing academic and functional advancement. You know, it's interesting to me to think that the same Supreme Court justices that have gone round and round in this last year about abortion and, you know, some other major issues are talking about IEPs, the stuff that that we talk about every day. So that just lets you know that that the Supreme Court justices are not experts on, they're experts on the law, but they're not experts on the topics that they deal with about the law, because we're the experts on IEPs and they're the experts on the law, but here they are talking about IEPs. So they're not the experts on healthcare. They're not the experts on abortion. They're not the experts on IEPs. They're not the experts on all these other things that they deal with, but they decide the laws that govern what we do, which is just fascinating to me. So people that don't know anything about IEPs are deciding what we do with IEPs. Just a fascinating idea to me. Okay, so here are the purposes of the IEP. Communication and collaboration. How we manage what's going to happen with a student while they're in special education. An IEP helps us with the accountability that we have for students through special education. They help us with compliance with our laws and with the monitoring of our compliance. And then they help us evaluate a student's progress. Hi, Megan. We just got started. So IEP development procedural requirements. An IEP must be drafted in compliance with a detailed set of procedures that emphasize collaboration among parents and educators. And this was part of the Andrew decision just a few years ago in 17. The procedures required in the IEP process represent when and how of IEP development. And then hearing officers can rule against a school on some procedural grounds only if the procedural violation impeded the student's right to receive a FAPE or impeded the parents' opportunity to participate in educational decision-making or caused a deprivation of educational benefits. Your book talks a lot about all the ways that we can screw up the IEP process, and it can be a little daunting. There's a question, the last question on your quiz today is a gimme, it's a throwaway. It says in the Wednesday webinar, what was the secret code that Dr. Cavan gave you? And the last one is if you want to get out of the classroom into a cushy, low stress job, you should become a diagnostician. And of course, that's not the right answer because it's not the avenue to a cushy, low stress job. The other choices are Public Law 94-142 and 504 is greater than IDEA, or choose C. And I'm going to pick Public Law 94-142 as the right answer on that secret question. Okay, so the answer to the secret question, which is the last question, is the first answer, which is Public Law 94-142. And that was, you know, the origin of IDEA, but that's the answer to the secret question. Okay, everybody got it? Public Law
Got it.
94-142. All right. But all that to say that this is not a low stress, cushy job as a diagnostician. All of you that are on the screen right now are in our diagnostician program. And there's lots of stress because there's lots and lots of ways that you can screw up. And the IEP is one of those. Examples of procedural errors: failing to involve parents in the IEP process, predetermining a student's placement or services, determining a placement before programming, failing to assemble an appropriate IEP team, or failing to include some of the components in the student's IEP. All of these things,
Dr. Cavan.
sometimes, but they're usually
Dr. Cavan,
yes,
the secret answer is C.
C. I didn't know you were on here. That's my husband.
We forgot to talk about that.
Well, how are you? The secret answer is C. And
Yes.
I don't even see you on here. There you are. You're me.
Yeah, you don't want to see me.
I didn't know you were on here. You're not supposed to be on here.
Goodbye.
Goodbye. Okay. Disregard what I just said. Choose C. It says choose C, so choose C. Okay. He helped me with the quiz, and I guess he made C the right answer. So choose C. Okay. Choose C. So on the secret question, choose C. I guess that's pretty obvious. It says choose C. So the other Dr. Cavan is working in the background and messing with my quiz. All right. So everybody got that right? Choose C. C. All right. I don't know how he just happened in here without me seeing him. Very strange. He's supposed to be downstairs cooking my dinner. All right. Back to what I was talking about. Lots of ways that that you can make errors in your IEP. We do fail to involve parents a lot. One of our questions, though, on our quiz is, can you have an IEP meeting without parents there? Does anybody know the answer to that? Can you have an IEP meeting without a parent?
If they gave permission.
Uh-huh.
It's what?
If
Yes.
they've given permission.
If they give permission? What if they never do answer you? What if you give them multiple notices?
Then you can hold it, correct? And
Yes,
then
you
you
can.
have to give them a follow-up. You have to give them a written letter with,
Right.
if
Now,
you try
you
to make
cannot,
contact.
what you cannot do is you cannot admit a student to special ed and provide initial services without parent permission. But you can hold an ARD meeting without a parent. And you notice I just used the term ARD. And what we have all through our book and through our slideshow here is IEP meeting. And we've talked about this, and I think you all probably already know that in Texas, we use the term ARD, admission, review, and dismissal. That acronym ARD, more often than we use IEP meeting, but those two terms are interchangeable. We probably ought to use the term IEP meeting more regularly because it's really a better term and it's more understandable to people from other states. It's a more inclusive term, and it's a superior term. I don't know how we started using ARD. It predates me, and I've been at this, since 1980. So we've been doing it, that long. Special ed's only been a legal requirement in our state since 1975, and I've been here in ARD since I started in 1980. So, I think it's been around since special ed started in Texas, but I think it's just an effort to be different, and I'm not sure that's always such a great idea. So, I think that one detriment to using the term IEP is, to using the term ARD, is that we then begin to think, and I referenced this in my notes at the beginning of the lesson this week, and that is sometimes we in Texas think that the term IEP refers just to the document. I've got a copy of their IEP, and that's their goals and objectives. Well, the IEP is the whole plan. We're the IEP team. We work on the IEP. The IEP follows the child, and it's not just the paper with the goals and objectives on it. It's more than that. And it's the whole plan, and not just the paper with the goals and objectives on it that you're going to hand to the teacher. And so I think the term IEP is more all-encompassing than this term ARD for ARD that references a meeting. And so I think that there are some districts in Texas that are kind of trying to move to the term IEP meeting and IEP team rather than ARD committee. And that's probably a good thing. You may have all been involved in ARD committees or IEP teams where students' placements may have been predetermined before you ever sat down at the table. And that's a procedural error. And we may all say, well, we know where that child needs to be when we sit down at the table. And that may be, but to make a predetermined decision about that is an error. We're supposed to come to the table with the notion of making that decision as a group with everybody's input when we sit down, and base it upon all the information that's part of that IEP process. And to have a decision made beforehand, or worse yet, based upon the child's eligibility status. Let's say the child has an intellectual disability, or has an emotional disturbance, or has autism. Based upon their eligibility for special education, we're going to place them in this class or that class or on that campus. That would definitely be a procedural error that, if brought to due process, the parent would most definitely win. Predetermining placement before programming, all of that falls into what I was just talking about. Failing to assemble an appropriate IEP team. Now, we'll talk in just a minute on another slide about the IEP team, but again, that's a procedural error. Or failing to include any of the required components that we're going to look at in just a minute. So here is that IEP planning process: the referral to special ed, and if the referral is approved and determined that the child does need formal assessment, then yes, the school obtains informed consent from the parent to evaluate. And then the evaluation is conducted. The team conducts the assessment. If the student is eligible, then the IEP team is appointed. The IEP team develops the IEP, and the IEP team determines the placement. That's a pretty good flow chart right there. Now, let me back up for just a second. The team that conducts the assessment here on number 2, that's the team that we call the multidisciplinary team, the MDT, the multidisciplinary team. And that team consists of the evaluator, the diagnostician, the school psychologist, the speech language pathologist, maybe the nurse, maybe a doctor, whoever is part of making eligibility determinations. We're also taking information from teachers, other specialists, maybe related service personnel, maybe an occupational therapist, or a physical therapist, or a music therapist, or all kinds of other people that might be part of that team. We're going to get input from parents. As part of that team, that conducts that multidisciplinary team assessment. Then an IEP team member can be excused under certain conditions. But those are very specific conditions. We do have to have parent permission to excuse an IEP team member from our meeting. They can complete their work using other than face-to-face meetings. IEP meetings and reevaluation meetings can be consolidated, but changes to the IEP meeting can be made via amendments rather than redrafting the entire IEP document. So you'll hear people talk about making an amendment to a meeting, and we can do that in certain circumstances. Not everything can be conducted via an amendment. Placement, for instance, cannot be changed via an amendment, but we can add or amend a student's accommodations, let's say, or other things that are, maybe we could add transportation, other things like that. We can make amendments to the IEP via that route. Now, here's the IEP team. Who's on that? Well, first and foremost, the student's parent or guardian. They are an essential member, a required member. And then we have to have a special education teacher and a general education teacher. If the child is not in special education yet, then we get the special education teacher that would serve the student. If the child is in special education all the time, never goes into general ed, and we hope that doesn't happen very often, but if that's the case, then we would get the general education teacher that would serve the student if they did have a general education teacher, whatever grade level they're in. Then we have to have a representative of the local education agency. Well, who is that person? Who is a representative of the local education agency?
The administrator.
The
the
administrator. Exactly. That's usually the administrator. Now, in some schools, that's going to be the principal. Other schools, they designate the assistant principal. I've been in some schools where they send the school counselor to all of the ARD committee meetings. It can be anybody that's designated at the campus level to be the LEA representative. I've been to some ARD committee meetings where it's the special ed director who's been designated to be the LEA representative for that particular meeting. The key criteria for this particular person is to be able to speak to the resources of the district. So they've got to be able to commit financial resources for the district. And usually that's going to be the principal, the assistant principal, or they, like I say, they can designate somebody, but it's got to be somebody that has the authority to speak for the resources of the district. Now, I always tell the story about when I was an assistant principal in a district years ago, and the parent asked for an air-conditioned bus in an ARD committee meeting. And we didn't have any air-conditioned buses in our little rural school district. And I sat there as a young administrator and wasn't sure what to do. And the parent was very savvy, knew a whole lot about her rights as a parent. And she said to me, well, you're the district representative. You're supposed to be able to speak to the resources of the district. So why can you not tell me right now that you'll get me an air-conditioned bus? Because that's your job in this ARD committee meeting. And she was right. She knew the law, and I was supposed to be able to speak to the resources of the district as the representative of the educational agency in that meeting. But I didn't have the authority that I knew of to commit the district to obtaining an air-conditioned bus. So I stepped out of the meeting and I called over to the superintendent's office and said, you know, what am I supposed to do in this circumstance? And they said, well, what we'll do right now is we'll contract with the mother and we'll pay her to transport her own child to school for the time being. Well, the mother didn't want to have anything to do with that. She didn't like that idea. But what we ended up doing was getting I think they rented a van for the short term that had a lift on it. The child was in a wheelchair, and rented a van with a lift, and then had to contract with a driver to drive that vehicle as well. But I really was supposed to be able to speak to the resources of the district, but we were talking about a pretty hefty expenditure that I wasn't sure at the moment if we really could afford that. But that's the job of that person. And then next is a person who can interpret the instructional implications of evaluation results. Now that would be our diagnostician, school psychologist, speech language pathologist, whoever is going over evaluation results in a particular meeting. If evaluation results are going to be discussed. Now, if evaluation results are not going to be discussed, then that person doesn't have to be there. But oftentimes in many districts, the diagnostician is the one who is keeping notes during a meeting, or who's acting as the scribe, or the person who kind of coordinates the events of the meeting. Usually our district representative is chairing the meeting, but oftentimes our diagnostician is the one who is acting as scribe or coordinator, and or case manager. And sometimes that's the special ed teacher in some districts, but those people have varying roles in the process, and so they act in sometimes more capacities than just the one that's listed here. And then the child, when it's appropriate for the student to be there. Certainly at the secondary level, it's going to be appropriate for the student to be there. Then we'll look at any questions about any of these people. Let me talk for just a second about excusing a member of the ARD committee. We do have to have the parents' permission to excuse any of these people for any part of the meeting, and we have to have it in writing. So you've probably all been in ARD committee meetings where somebody, maybe the general ed teacher or the special ed teacher, or maybe even the principal, got up and left for one reason or another. Oftentimes I've seen general ed teachers get up and leave the meeting. They've got to go and pick up their class from the lunchroom, or from specials, or it's recess time and they've got to get their class from recess or PE, and they've missed the last 20 minutes of the meeting. Not okay. And principals will say, well, it has to be okay because that's our schedule. That's the way our schedule runs. Unless the parent agrees to that in writing, it is not okay for anybody on this list to be excused from the meeting without written parent permission. Special ed teacher says, I've really got to run. I'm on duty. School's almost over and my duty starts, in 5 minutes. Not okay, unless you have it in writing from the parent, for anybody on this list to be excused. Districts don't like to hear that, but that's the rule. And anything other than that is a procedural error. So other people that are on the IEP team, but are not required members, any related service personnel, OT, PT, music therapists, other people along those lines, a person with expertise in assistive technology. So when you're talking about AT, you've got to have people with expertise in that area. For a transition IEP, a representative of the agency that's likely to be involved in that process. So when kids are at the secondary level, or the little bitty ones coming in, we have to have somebody that knows about the agency that the student is transitioning from or transitioning to. Other persons at the discretion of the parent or the school. Now this is the part C. These are for our little ones that are transitioning in from ECI. What we don't have on this list is what's specific to Texas. In Texas, we've got the requirement for CATE, the career and technology services. When kids are enrolled in career and technology courses at the secondary level, we have to have a CTE representative in our ARD committee meetings. And that's a specific rule to Texas. That's of course not on this list because this is a national perspective, federal perspective.
And I have a question.
Yes, sir.
So, at one of the schools on the IEP facilitator for, they said that I have to have a CTE rep if they're an 8th grader and for transition and CTE.
Yeah, if they're
They're in a Kate class.
right. If they're in a
Okay.
CTE class, you've got to, and that's a Texas rule.
Okay, so if they're
Yeah.
not, I don't actually have to invite the CTE rep?
Right. Unless your district has some weird rule. I mean, they may have some
Yeah.
expectation at the local level.
Okay, well, and like I said, it's two schools in the same district, so one of them is saying I don't have to, and the other one is expecting it, and I'm like, so now I can definitively say if a student doesn't have CTE, like, you know, then I don't have to have CTE. Okay,
Right.
That's fine.
Now,
that's what I
yeah.
need.
And if you want, we can on Saturday, remind me, and we'll look at the legal framework and I can show you exactly where it says that. Okay?
Okay,
Make
okay,
it- But you have to remind me because I've got an old brain. Okay?
I will.
Remind me and I'll
Good.
show you where it is. Okay?
All right.
Okay. So
I'll
then
remind you.
we've got the elements of the IEP here. And all of these things are required. Now, most of you are working with software from one of these companies, eSped or Easy IEP or Success Ed or one of the others. And all of these components will be in there. And that's why our school districts love the software, because the manufacturers of the software embed all of those components into the software so that it's there for you. So you've got to have a statement of a student's present levels of academic achievement and functional performance. That's the PLAFs. And we talked a little bit about this last week, how teachers are usually the ones who come up with the PLAFs, and it's got to be in the IEP. So if a teacher gets to an IEP meeting and says, oh, I forgot the PLAFs, well, then you don't have a legal IEP if you don't have the PLAFs in there. And you can't wait on it because you're supposed to have it while you're there in the meeting. So an IEP without PLAFs is not legally, procedurally defensible. It's not what it needs to be. A statement of students' measurable annual goals, including academic and functional goals, short-term instructional objectives for students who take alternative assessments. Now, remember, if you've been at this very long, you may remember when this was not the rule. We used to have short-term instructional objectives for everybody, but that's not the case anymore. Now we only have to have short-term instructional objectives for kids who take alternate assessments. And then it says here, consult state law. I'm getting a message that says my internet's unstable, so I may be cutting out on y'all. I hope not. It says consult state law or regulations regarding short-term objectives. Some states still require short-term objectives. Our state says that you don't have to have it for kids taking only have to have it for kids taking alternate assessments. Your district may require more than that. You can always up the ante. But the law in Texas right now is that you only have to have the broad goals, except for the kids on alternate assessments. A statement of how the student's progress toward meeting the annual goals will be measured, and when periodic reports on the student's progress toward the goal will be provided to parents. A statement of the special education related services and supplementary aids and services based on peer-reviewed research to be provided to the student, and a statement of the program modifications or supports for school personnel. So all of these are requirements. An explanation of the extent, if any, to which the student will not participate with students without disabilities in general ed. A statement of any modifications necessary to meet the academic and functional performance of the student on state or district-wide assessments of student achievement, or a statement of why a student can't participate in a regular assessment. And how an alternate assessment was selected. The projected date for the beginning of the services and modifications, and the frequency, location, and duration of those services. a statement of appropriate measurable post-secondary goals based on age-appropriate transition assessment services and transition services needed to assist the student in reaching those goals, and a statement of the program modification or supports for students, for school personnel for students who are of transition age. And then you've got the list of special considerations. For students whose behavior impedes their learning, you've got to consider positive behavior interventions and supports. For kids with limited English proficiency, you've got to consider their language needs. For kids who are blind or visually impaired, you've got to provide instruction in Braille unless an evaluation shows that Braille is not appropriate. Got to consider the communication needs of the student who is blind or visually impaired, and what their language or mode of communication is, their academic level, and their full range of needs. And then you've got to look at AT when it's appropriate. Here's a flow chart for IEP development. I'm not going to go through all that step by step. We've just kind of talked about it, and this will be on Canvas as well. The substantive requirements are satisfied when the child's IEP sets out an educational program that is reasonably calculated to enable the child to make progress appropriate in light of his circumstance. So we want everybody to be able to make progress. And this Andrew case that occurred in 2017 kind of upped the ante. We've talked about this a little bit this semester. It increased what we expect, the level of progress we expect for kids from where it was with the Rowley case back in '82. School districts have to do more than provide just that floor of opportunity. We've got to help them to make progress, not just provide that very basic floor of opportunity. The substantive requirements of a student's IEP represent the what of an IEP, and thus the actual content of his or her special education program developed in the IEP process and memorialized in the IEP document. So here are some substantive errors. Failing to conduct a complete and individualized assessment of a student's needs. Failing to include all the student's educational needs in the present levels of academic achievement and functional performance section of the IEP. Failing to write challenging, ambitious, and measurable annual goals. Failing to monitor the student's progress and make changes when needed. We've probably all seen examples of one or more of these in the situations that we've come across as educators. So we hold that a material failure to implement an IEP violates the IDEA. A material failure occurs when there is more than a minor discrepancy between the services a school provides to a disabled child and the services required by the child's IEP. It's important that IEP teams ensure that after a student's IEP is developed, that it must then be implemented as agreed upon. A failure to implement an important or material component of an IEP may be a denial of FAPE, even if an IEP is procedural and substantively correct. So you can see there are just tons and tons of places where we can screw up. Lots and lots of places. We've got the
I have
idea.
a question about that.
Sure.
So if you do make an error, what if the parent's not knowledgeable? Do you bring it up, like say, oh, we messed up and the IEP is not valid, or do you wait for the parent to catch it?
I would not wait for the parent to catch it. I would
Okay.
make a good faith effort to fix the problem.
Okay,
Yeah,
that's what I
would do.
figured, but
Yeah, you don't want to wait because, and so many of us work in schools where the parent group is uninformed.
right.
And I've worked in lots and lots of Title I schools where the parents are just doing their best just to get by, and they're doing good. They're doing good just to get their kids to school. And some of them never make it to an art committee meeting. And they're really reliant on the school to do what's best for their kids. And so we've got to just, you know, take the high road and ethically, you know, check ourselves, make sure that we've got good IEPs out there. And then when we realize that we don't, we need to, you know, fix it. I
So
don't
do you
think-
go to another IEP meeting if there wasn't procedural error or something?
Well, if it's something you can fix with an amendment, you fix it with an amendment.
Okay,
And if you can't, then you call another meeting and
Okay.
you hold the meeting and you remedy what you've fouled up.
okay.
And it's a, you know, I think that good school districts have processes in place to check themselves, to make sure that they're doing what they need to do.
Mm-hmm.
You've got this, you know, the procedural side and the substantive side, I think are really interesting, and it's an interesting way to compare, you know, getting everything right to the letter of the law or the spirit of the law. And the substantive side is kind of the spirit of the law. Are we writing challenging IEPs that do right by students? Or are we, you know, are we writing challenging goals and objectives that really, you know, like I said, you know, do right by kids? Or are we just, you know, is it that basic floor of opportunity, or are we doing what we really should instead of just what we have to? And I think that there are some school districts that just play the game and do the very least, and
Mm-hmm.
scrape by with dotting the i's and crossing the t's, and other districts that you can tell really want to do the very best for the kids that they serve.
Mm-hmm.
What I think is unfortunate is when those districts that are really trying to do what's right find themselves the target of maybe an overly active advocate who wants to nail everybody for, you know, little procedural things.
Mm-hmm.
And then, you know, their good efforts just go unnoticed, and they get nailed for little procedural things, instead of their good efforts being rewarded. That's the thing that kind of bothers me. Sometimes
Mhm.
you'll find in certain areas there'll be an advocate or a special ed lawyer that gets out their name in the community of parents, and some parents will just, you know, latch onto it and run with it and start following due process against a particular district. Now, if it's a district that's not doing right by kids, I'm all over that. I'm glad when that happens, you know, to maybe hold them accountable. But when districts are doing what's right for the most part, and they just have a little procedural issue, you know, a blip every now and then, and somebody hones in on it and just, you know, like a vulture on, you know, a dying animal. It's pitiful when that happens sometimes. And they just are relentless. Some of the special ed advocates I run into in my career have just been relentless, just hammering at
I'm
districts.
sure.
So I hate it when that happens.
I have one of those arts tomorrow after school.
Do
The
you?
mother, yeah, she said, we have to have it at 4, and it's going to take more than one meeting in order to get this art done. And we were like, ma'am, and she's bringing an advocate. And I
I'm
was
so
like,
sorry.
I'm like, wait a minute. And she was like, I don't want the IEP facilitator there. And luckily, the director of assessment, or director of the behavior therapist, I guess, told her, ma'am, that's not an option. We have the IEP facilitators are there to be a scribe in this sense. So I have to be there. And they're like, I'm sorry. I was like, it's okay. I have to get my feet wet and baptized by fire sometime.
Yeah. See, that happens sometimes. And for a while, there was an advocate that was very active out there on the north side of Fort Worth, and in several of those districts from your district on north, you know, Eagle Mountain, Northwest, South Lake, you know, all of those districts that are from Loop 820 up north, and just relentless. And was, I think she must have been keeping score to see how many due process cases she could get filed in some of those districts. And it was just awful. I felt so bad for those districts, and most of those districts that I just mentioned are really trying hard to serve kids really well. And to see those efforts just slammed by people that, you know, I don't know, it's disheartening to see that happen when there are good educators who are doing their very best, to have to deal with that as part of their what's already a difficult workload. I hate to see that. So we've got the IDEA and the laws implementing regulation requires that IEPs include information that allow a student to be involved in and progress in the general ed curriculum. So we know that this is the swing that we're taking now, that our IEPs focus on what the general ed curriculum focuses on. So that's our standards based. What are our current general ed standards? That's where our special ed IEPs need to be focused. According to the standards-based IEP approach, the task of the IEP team is to determine how a student is currently performing academically, compare that performance to what he or she, that should be he or she, not she or she, may be expected to do on grade level academic standards for the grade in which the student is enrolled, and write goals and determine services that will help to close that gap. The standards-based IEP is not a restatement of the state content standards, nor is it an IEP in which a student's goals are taken from the state standards. I think that's what a number of people thought for a while, that it was just taking the state standard and putting it into an IEP. So here are some lessons that we learned. Ensure that the procedural requirements of the IDEA are followed. Involve a student's parents in the development of the IEP. Assemble the appropriate team and make sure they stay for the meeting. Develop an IEP that will enable a student to make progress. Ensure that all teachers and related service providers understand their responsibilities as listed in the IEP, and ensure that the IEP is implemented as written. Okay, let's look quickly at chapter 12, procedural safeguards. In special ed, procedural safeguards guide the method by which school officials make decisions regarding the education of students with disabilities, and substantive due process rights are those personal rights that school officials may not abridge. Congress established the elaborate system of safeguards to guarantee parents both an opportunity for meaningful input into all decisions affecting their child's education and the right to seek review of any decisions they think are inappropriate. An IEP must be drafted in compliance with this detailed set of procedures. These procedures emphasize collaboration among parents and educators and require careful consideration of the child's individual circumstances. And you all know that you've got to share the procedural safeguards with families at least once every year. The procedural safeguards include these things: notice and consent requirements, the right to examine relevant records, procedures to protect the rights of a student when their parents are unavailable, an independent educational evaluation, the process of voluntary mediation. You can do that before you actually go to due process. The opportunity to present a complaint to the state education agency, and then due process, the actual hearing process as well, and possibly filing a suit in state or federal court. So I'm not going to read all of this to you, but this is the notice requirements. And the procedural safeguards themselves are printed on, you can get to them from the TEA website, but they're actually on the legal framework, on the ESC 18 legal framework that we've talked about. And this Saturday in our EDSP 5329 class, we're going to talk about the procedural safeguards themselves, and we're going to go over the document in some detail. But we'll talk specific, we'll talk about it for just a minute here, but we're going to dig do a deep dive into the procedural safeguards on Saturday. But the procedural safeguard notice, once during every school year, districts have to provide a copy of that to a family. And you have to provide it then after each initial referral, upon receiving a parental request for evaluation, upon receipt that the parent has filed a due process complaint, and when a school district's disciplinary removal constitutes a change of placement. So there are certain times you have to give one to a parent over and above that once a year. Then here's a list of all the times that we have to give consent, or get consent, I should say. Consent is a critical element of the special education process. There are a lot of things we cannot do without written consent from parents. We've got consent forms. You'll all have them in your special education management system, and you give them out and get consent a lot. But here's a list right here that tells you when you're evaluating a child to determine whether the child is eligible for special ed and related services. So your initial evaluation, providing special ed and related services. So you can't begin services. You've got to get consent in order to do an evaluation. And then you've got to get consent to place a child in special ed. You've got to get consent for reevaluating a child. You've got to get consent to allow an IEP team member to be excused. We've talked about that already today. To implement an individualized family service plan. That's for our little children, in place of an IEP. To access private insurance information and enable a child to fully participate in the special ed process. So when obtaining consent, the school district personnel must ensure that parents are fully informed, which means that the parents have been informed about all of the above, about all information relevant to the activity for which consent is sought. And it has to be in their native language. That they understand and agree in writing to the proposed action for which their consent is sought. And they understand that granting their consent is voluntary and it can be revoked at any time. Now, when we get consent from a parent, we've got to make sure that this last paragraph is happening, that they understand what they're giving consent for and that they can revoke it. So we can't just shove a piece of paper in front of them and say, sign here. We've got to explain to them what they're signing and why. So that's what the informed part is. It's called informed consent because we are informing them as to the process what's going on. Now, IEEs, independent educational evaluations. If a parent disagrees with a school's evaluation, they can request an IEE at public expense. And I think we talked about this last week. Or at least we have sometime in the last few weeks. This is where a parent disagrees with the evaluation that's taking place. And we talked about this with our chapter last week was about evaluation, and we talked about this with evaluation. So the parent disagrees with the evaluation that's taken place, and they can request an independent evaluation that will mirror that evaluation. They can only request an evaluation, an independent evaluation that's in place of the evaluation that they've just had. So if you've done a cognitive evaluation, they can ask for a cognitive evaluation. But they can't ask for an independent autism evaluation if you haven't done an autism evaluation. The district has to do an evaluation first in order for the parent to request an independent evaluation. It has to be in answer to an evaluation you've already done. They have to disagree with the results of an evaluation you've already conducted at the school district level. And then the independent evaluation will be an answer to that. And they can't just go out and get it from anybody anywhere. That has to be approved by the school district. Now, what the school district usually does is they give a list of approved evaluators, but parents are usually suspicious of anything that the district gives them. So they'll say, well, I don't want anybody off of your list. Whoever you give me a list of is just going to agree with what you say. And so you can say to the parent, well, then you can find a person that you like, but then we have to approve of that person. So then the parent goes out and finds, Dr. John Jones down here on the corner. But then the district gets to look at John Jones's credentials and his fee schedule. And if the district doesn't agree with his fee schedule or approve of his credentials, then the parent's going to have to go looking again. And we have to come to an agreement on the person, their credentials, and their fee schedule before we determine that the district is going to pay for that evaluation. Now, when we do, we pay for it. We work it out with Dr. Jones down there. We don't ever give the parent money. We don't ever give the parent a voucher. We work out the payment between us and Dr. Jones. And then we take Dr. Jones's evaluation into the district. Now, do we have to abide by Dr. Jones's evaluation? No. We have to, here's the key word, we have to consider Dr. Jones's evaluation. We don't have to take it lock, stock, and barrel and put it into our IEP and agree with it and abide by it. We have to consider it. Sometimes it's a great evaluation and we want to go with it and approve of whatever Dr. Jones said. And sometimes it's hogwash and we don't, but we do have to consider it. And we'll put it into our record and say that we considered it and we agree or disagree with it. So let's say that we conduct then another evaluation. That was our cognitive evaluation, but now we decide in the next 6 months that we're going to do a speech evaluation and an autism evaluation. The parent can disagree with both of those and request another IEE for speech and autism and find evaluators to do those. But they can only get an IEE for an evaluation that we've done. And they can only get one IEE for each evaluation that we do. So there's my speech on IEEs. Dispute resolution. If a student's parent believes that a school district has not followed the procedures of IDEA, or they disagree with actions involving identification, evaluation, or placement of their child, they may use the dispute resolution mechanism. If students are eligible under IDEA, the dispute resolution mechanisms include mediation, resolution sessions, and due process. And they can go through any one of these processes. It's not a chain that they have to follow. They don't have to do mediation first, but they may choose to. And we always like it when they do. Additionally, each state has a complaint, investigation, and resolution process. So here are the state complaint procedures. And I'm not going to read all of this to you, but there are procedures that you have to go through for complaints. All of this is in your textbooks as well. And then here's the mediation process. And again, I'm going to post all of this on Canvas, but it's a consolidation of what's in your book. And then resolution. Then we get to due process. The purpose of due process is to resolve disputes between parents of children and youth with disabilities and school districts regarding identification, evaluation, programming, placement, or provision of FAPE. Parents must file within 2 years of the date that they knew or should have known of the action that forms the basis of the complaint, unless a state has a different timeline. In a due process hearing, an impartial third party, the due process hearing officer, will hear both sides of a dispute, examine the issues, and settle the dispute. I've been involved in a few due process hearings, and they are very nerve-wracking. I've been in a district that had due process filed against them. I've also been a witness in another district that had due process filed against them. And I've been in districts where they won, and I've been in districts where they lost. In a hearing, Both the parents and school districts have the following rights: the right to be accompanied and advised by an attorney and by individuals with special expertise with respect to the problems of children with disabilities. And this is what I was in the one where I was a witness. I was considered an expert witness for another district. The right to present evidence and confront, cross-examine, and compel the attendance of witnesses. The right to prohibit the introduction of any evidence at the hearing that has not been disclosed to the party. It's very much like a little trial. The right to obtain a written or electronic verbatim record of the hearing, and the right to obtain a written or electronic finding of fact and decisions. Criticisms have been leveled at the system of dispute resolution, especially due process hearings, as being too expensive, time-consuming, adversarial, and emotionally draining for all parties involved. And I would second that as having been part of it. It's very draining, very adversarial. It's a very unpleasant process. Facilitated IEP meetings were very popular for a time. I don't know how much people are using those anymore. When I was working at the service center about 15 years ago, those were all the rage, and we were doing trainings that came out of TEA about facilitated IEP meetings. I don't know that they're being used much in Texas right now. Have any of you had any experience with facilitated IEP meetings? Ombudsman, third-party consultation, all those are very similar, where we get somebody to come in from the outside and help with IEP meetings to help those be less adversarial on the front end so that we don't have to get to the point of due process. We're about out of time, so I'm just gonna hurry through these last few slides. Things that can happen. Usually there's no actual payment to parents. You can get tuition reimbursement, you can get attorney's fees. But it's not a money-making opportunity for the plaintiff, the parent. Compensatory education, sometimes that happens. Occasionally there is punitive damages, but not often. Monetary awards or actual damages. Doesn't happen very often. So what are the lessons that we get from litigation and legislation? We want to adhere to the procedural systems developed by school districts to ensure that IDA's procedural requirements are met. It's really critical and essential that we follow the rules. It's a rule-driven system in which we find ourselves as special educators, very rule-driven, and we want to adhere to them as closely as possible. And you'll have people that you find in your pathway. Oftentimes they are school administrators that will say, or teachers that will say, we don't do that here. We don't follow that rule. That's not the way we do it. We've never done that here before. But the rules are there for a reason. And there are parents and advocates and attorneys that will look for those places where school districts aren't following the rules, and they will nail them. And you as the special educator will find yourself in the crosshairs if you're not careful. So try to help educate the people at your campus or in your district about what is a rule and what's not, and then follow the rules. Ensure that administrators and teachers understand their responsibilities, things like PLAFs and goals and objectives that are requirements that other people need to be fulfilling, that are part of an actual law. They're a law. And if they don't fulfill it, it's the violation of a law. Ensure that parents are meaningfully involved. If parents aren't involved, that's a violation of the law. Ensure that all administrators, teachers, and related services understand their roles. And we're doing it all for children, and for children who have a disability. And I think that's critical. You know, I think we talked about this in one of our Saturday classes a few weeks ago. There's a trend to not use the word disability, to use the word difference or differently abled or things like that. That's very politically correct, but I still prefer the term disability because it is a disability. The children that we are serving have disabilities, and it's not they're not just differently abled, they are disabled. And it's not a good thing. It's a negative thing. It makes it sound happier if we say we're just differently abled, but it is a disability. And we are trying to help someone who has something negative in their lives. We're trying to make their lives better. And the way that we do that, one of the ways that we do that is to follow the rules that have been set out and get the people that are there with us at the local level to see what their role is in that process and to follow the rules as well and to do their part in making sure the IEP is legal on the front end and then is followed. And that's one of the things that we can do to assist children who have a disability. Okay, let's see. That's it. I'm done. 5 after. Okay, let me look at some of my quiz questions and see if there's anything else. Notices sent to parents need to have a description of the action proposed. Description of the action proposed. Remember that bonus question is 2C. Here's one. The procedural safeguards give parents the right to challenge all of the following except for, and the one they can't challenge here is the teacher assigned to their child. They can challenge the special ed placement, special ed related services, the identification, and then one of the answers is the teacher assigned to their child. They can't challenge that through their procedural safeguards. Then here's a true false question under the procedural safeguards. Even minor changes in the child's special ed, such as moving the class to a different room, requires notice and consent. That's false. But when the LEA, the local education agency, proposes to initiate special ed services and placement for a student, the parent's consent must be obtained. That's true. Then there's one about who has to be in the IEP meeting. And then there's, it has all of the people listed as required. It even has the child required. The child is not required. When kids move from one district to another, the child's former IEP should be implemented until the new district evaluates the child and creates a new IEP. And that's true. All right. Folks, we've come to the end of our time together and a little bit additional. So I'm going to close it out. All right. Any questions?
I have a quick
Concerns?
question
Yes, ma'am.
about the final. Is that next week?
No, we've got one more
No.
week like this and then
Okay.
the final. Okay.
Okay.
Um,
All right.
and I need to get my other discussion board up so y'all can have your little discussion about this week's case briefs. I'll open
Mhm.
that tonight and it'll be open through Sunday, okay?
All right.
All right. DJ, did you finish your supper preparation? You can't. I can't hear you if you're talking. Okay, good. Okay. All right. I'm gonna shut it down, folks. And I'll see all of y'all on Saturday. Think, yeah, I'll see
All
all of
right.
y'all on Saturday. And
Bye.
this week's assignment won't be due till Sunday night, okay? For this class. Okay? All
Okay.
right. All right. We'll see y'all. Have a good remainder of the week.
Bye.
Bye-bye.